What if you spent your entire life savings and then had to wait over 20 years just to get a final court date? Seriously, imagine enduring all that financial and emotional stress. Think about the endless paperwork, the absolute maze of confusing legal jargon. Whole generations of a family passing by while waiting for a single verdict. And then, after all that, finding out that your file is sitting at the absolute bottom of a literal mountain of other pending cases. It sounds like a heartbreaking system failure, right? Well, that's exactly what we're talking about today.
That scenario, it's the harsh reality for far too many people today. So the question is, are you stuck at the bottom of the pile? Because the highest court in India is quite frankly completely overwhelmed. And look, this isn't just a problem for high-profile criminals or massive multi-billion-dollar corporations. It's a crisis that is deeply affecting ordinary citizens who are just trying to settle basic property disputes, enforce simple contracts, or protect their families. The waiting room for justice is packed right to the brim, and it's leaving everyday people totally in the dark.
92,800. Let the sheer gravity of that number sink in for a second. There are over 92,000 pending cases in the top court right now. That is an unprecedented docket explosion. I mean, if you were to take those physical files and stack them up, they would literally tower up into the sky. And we have to remember, behind every single one of those numbers is a real person, a small business, a community whose life is basically on pause, desperately waiting for an answer that just isn't coming.
So let's dive into part one, a landmark shift, expanding the bench.
A major legal landmark just passed in Parliament to try and address this very crisis. Union Law Minister Arjun Meghwal actually piloted the Supreme Court Number of Judges Amendment Bill, and it successfully passed, replacing an earlier executive ordinance. So what does this legislation actually do? It officially raises the total sanctioned bench capacity from 34 to 38 judges, and that includes the Chief Justice of India. Now, in plain English, a sanctioned judge just means the maximum official number of seats that are allowed by law. Think about it like adding 4 brand new desks to an insanely overcrowded classroom. The system is finally acknowledging, hey, the current teaching staff just can't handle the number of students walking through the door. So we're adding 4 new permanent seats to the highest bench in the country with the hope of finally tackling this massive overflow of cases.
Now, to most people, adding 4 judges just sounds like, routine administrative paperwork. But this explainer matters directly to your constitutional rights and your daily access to justice. It's a structural thing. When the highest court cannot function efficiently, the entire legal pyramid beneath it starts to crumble. So today, we're going to look into this massive docket explosion, the historical expansion process, and why adding judges, while absolutely crucial, might not actually completely fix the backlog all on its own.
Moving on to part 2, how the court works, the rules of expansion.
Before we get into the deep end of the crisis, let's establish a few basic facts. Under Article 124 of the Indian Constitution, while regional high court judge numbers can be adjusted directly by the president, increasing the Supreme Court is totally different. It requires a formal act of parliament. And historically, as India modernized, the court had to desperately expand just to keep its head above water. It was originally established back in 1950 with just 8 judges, but it was quickly outpaced by a booming nation. As the population exploded and the economy grew incredibly complex, Parliament had to step in repeatedly. They bumped the bench to 11 in 1956, then 14 in 1960, 18 in 1978, 26 in 1986, 31 in 2009, and eventually they hit 34 in 2019. Honestly, it's the story of a system constantly running on a treadmill just to stay in the exact same place.
To truly grasp why keeping up with this demand is so incredibly difficult, I want you to imagine a single, world-class, specialized hospital in the middle of a massive city. Originally, this hospital was built by elite architects to treat only 50 ultra-critical, open-heart emergency cases a week. That's it. But over time, the city's population absolutely explodes from 10 million to over 1 billion people. Now, imagine if every time a local neighborhood clinic makes a tiny mistake or gives a patient an answer about a scraped knee that they just don't like, that patient drives straight past their local clinic, goes to your elite specialized hospital, walks through the front doors, and demands to see the top open-heart surgeon on duty to fix their scraped knee. The exhausted doctors are suddenly drowning in thousands of minor issues.
That hospital scenario, it perfectly mirrors our core structural problem. The original plan was actually brilliant. The Supreme Court was designed strictly as a constitutional court. It was supposed to be a high-level body meant to sit in large benches, interpret fundamental rights, and resolve massive country-altering disputes between states. But the modern reality is a bit of a nightmare. It has practically transformed into a routine appeals court. Instead of just handling those critical surgeries, our metaphorical hospital is spending 90% of its day running routine checkups, treating minor fevers, and handling basic paperwork. The highest judges in the land are spending their precious hours on local disputes rather than constitutional emergencies.
And the biggest driver behind this reality is something called special leave petitions. Let's break that down simply, because it's a game changer. A special leave petition is essentially a request by a regular citizen challenging an everyday decision from a regional high court. For example, imagine two neighbors are fighting over where exactly a fence should be built in their small town. They go to a local court, then they appeal to a higher regional court. Still unhappy with the result, they file a special leave petition to take this tiny, everyday fence dispute all the way to the Supreme Court. Because of this endless influx of local issues, the waiting room gets so crammed with thousands of petty cases that even the most critical life-or-death constitutional emergencies are forced to wait years just to get through the front door.
Which brings us to Part 3, the 92,000 case crisis, the new amendment bill.
This gets us directly to the core of what actually happened in Parliament recently to try and tackle this crisis. Following a massive post-pandemic surge in digital e-filing, which, made it easier than ever to submit those minor appeals from anywhere, the case pendency spiked to that record 92,800 mark. To combat this, the new legislation amends the 1956 Act to officially add those 4 new seats, because without them, a devastating cause-and-effect loop happens in the courtrooms. With only 34 seats, judges are forced to sit in small 2-judge or 3-judge benches just to clear thousands of daily bail applications and minor service disputes. Because they spend literally all their working hours on these daily matters, historic constitutional questions are left completely frozen in cold storage. And when fundamental rights questions are frozen, society stagnates.
Because of that exhausting daily grind, the court deeply struggles to assemble what is known as a constitution bench. So, a constitution bench is a large group of 5, 7, or 9 Supreme Court judges who are assembled specifically to resolve massive, foundational legal questions. They need uneven, large numbers to break ties and provide a wide diversity of legal thought on the absolute most important issues facing the country. The government highlighted that adding 4 new judges gives the Chief Justice some vital breathing room. It frees up senior judges so they can form these specialized large benches without having to entirely halt the daily court calendar that millions of people rely on.
But legal scholars point out a pretty major catch here. Expanding the sanctioned number of seats on paper only works if the real-world process actually flows smoothly. And there are 2 critical bottlenecks here. Step 1. The Supreme Court Collegium, which is really just a committee of the top senior judges, must swiftly select and recommend elite candidates. Step 2. The Union Law Ministry, which is the government, must process and clear those recommendations without long delays. If these 2 groups disagree, or if the paperwork stalls out for months on end, those 4 brand new seats remain empty. An expanded strength on a piece of paper means absolutely nothing if the actual chairs in the courtroom aren't filled by living, breathing judges.
Furthermore, eminent legal experts have issued a pretty stark warning. They say, increasing the number of judges is like putting a Band-Aid on a structural leak. Scholars and former Law Commission reports argue that we need deep listing reforms. Listing reforms simply mean changing the rules for how a case is scheduled and deciding what cases the court will actually hear on a Tuesday morning. Unless the Supreme Court strictly filters out trivial appeals and fixes its daily schedule, the sheer volume of incoming filings will just swallow up the extra 4 judges in a matter of months, and that leaves the core backlog exactly where it is today.
All right, Part 4. Why this matters and the impact on you.
Let's zoom out for a second and ask the ultimate question for everyone following along. So what, right? How does adding 4 judges to a court in New Delhi actually alter your daily life, your fundamental rights, and your personal access to justice? Well, every single year, massive legal questions regarding personal privacy rules, electoral regulations, and environmental protections sit completely frozen. Think about how electoral rules dictate the fairness of your local democracy, or how environmental protections dictate the literal air your family breathes. By expanding the bench to 38, the court gains the physical capacity to resolve these foundational questions faster. And on top of that, consider the direct relief for ordinary people. When commercial contract disputes or property cases drag out for decades, individuals suffer horrific financial stress, and small businesses face severe uncertainty that can literally bankrupt them. So a larger bench ultimately allows for faster disposal of these high-stakes matters.
However, this news also forces us to reflect on the broader picture of grassroots justice. True access to justice requires filling thousands of vacancies in local district courts and regional high courts. The Supreme Court is really just the tiny tip of the legal pyramid. The massive base, the district courts, that is where 99% of citizens actually interact with the law. So, while expanding the apex court is a fantastic and extremely welcome step, millions of ordinary citizens face the absolute longest delays right at the bottom, waiting years just to get a local hearing. A swift, truly accessible justice system requires continuous heavy investment from the bottom all the way to the top.
Finally, Part 5. A lasting solution, the path forward.
To wrap it all up, the passage of this amendment bill expanding the top court's capacity to 38 judges is for sure a vital legislative boost to combat an unprecedented backlog. But, as we've seen, adding seats on paper is just one step. The true test depends on swift appointments and broader system reboots. Which brings us to a critical, thought-provoking question for the future. Now that the Supreme Court's strength is expanded, do you think adding more judges is enough to clear our massive case backlog, or do we desperately need separate regional benches across the country to handle all those routine appeals? Think about how our system is structured and what it really takes to deliver timely justice for everyone. Thank you for diving into this explainer with me, and keep exploring the systems that shape our world.